Thanks, Michelle. Cheers. Court rise if able.
Mr. Barnes, would you like to introduce both counsel for first and second respondent, please?
Yes, my lady, good morning. In this matter, obviously, I appear on behalf of the local authority.
Yes.
My learned friend, Mr. Hall, represents the mother, who is at the back of court and I think outside of shot of the live stream.
Yes.
And Miss Thompson represents the child through her guardian, Miss Mitchell. I'm accompanied by the social worker who's currently allocated to the child.
Thank you.
Obviously, bearing in mind the live stream, and notwithstanding that with other programming available, it may be a niche occupation in the middle of summer, we were obviously intending to refer to the child as the child, the mother as the mother, and the foster carer as the foster carer, rather than using names. I hope that's satisfactory.
Well, that's very, very sensible. If any of us obviously slip up, that's unfortunate, but we'll try our best not to.
Thank you.
But you will not be surprised that we want to try and get a view of how things are going to go today.
Yes.
The new information that came,
Yes.
and which His Honour Judge Scarratt was quite certain should come before the court, quite rightly.
Yes.
Obviously came as something of a surprise to him.
Yes.
We have seen that new information has been accommodated, particularly by Mr. Hall in his skeleton argument addressing the appeal.
Yes.
But is there anything else we should know, Mr. Barnes, that's happened in the meantime?
Well, I haven't had the opportunity to discuss matters, and so there may be matters that aren't quite in agreement. Certainly, following on from His Honour Judge Scarratt's decision, the mother left the foster placement.
Right.
So that has now taken place. There have been contact sessions that have been arranged. There have been some, I'm informed, that were missed. It looks as if perhaps one in every 3 or so during June were missed. And as I understand it, there has been something of a breakdown as between the mother and the foster carer's relationship, to the extent that the foster carer is not supervising contact anymore.
But I thought that Judge Scarratt said that they weren't to be supervised, they were to be supported, the contact sessions.
At present, they are being supervised, and there remain some anxieties from visits that have been undertaken as to the mother's present situation, and obviously there is a continuing issue of this appeal.
Right, okay. All right. So, all counsel are aware that Lord Justice Peter Jackson thought that there was some reason to send out a direction to parties before he considered the grant of application for permission to appeal. And obviously, parties have looked to see whether or not that direction could be complied with the ultimate end of compromising the appeal.
Yes.
In order to remit this case.
Well, my lady, certainly the submissions are included within the bundle. The local authority and on behalf of the child were both content to compromise the appeal on that basis.
On the basis that it all went back?
No, because the invitation from Lord Justice Peter Jackson was simply to set aside the refusal of the placement order application.
Yes, of course, but if it went back on the refusal of the placement order, one of the matters raised in Mr. Hall's skeleton argument as an alternative, if he does not succeed in heading off the appeal, is that if this matter goes back, then it's to consider everything again. It's not just whether or not this is placement or foster care, it would be open season, in other words.
Yes, my lady, I understand that's the approach
Yes.
that Mr Hall invites. There are...
So the way that the local authority and the guardian put the case is different. You say that that the concession would be to remit the case to another judge in order that they should deal only with whether or not to make a placement order.
Well, that is what the appellant's notice is focused on, and the local authority's primary case. There is the technical observation that there isn't a respondent's notice in relation to the making of a care order, but I accept that it may be that the court takes the view that the reasons are sufficiently inadequate, that the matter needs to be considered entirely, and I don't seek to suggest that the court is necessarily bound solely by the confines of the appeal, and if the court considered the appropriate disposal included setting aside the care order to allow all options to be considered, then I accept that that is a disposal that is available to the court. In a sense, both Mr Hall and I have slightly contradictory positions on it. Fundamentally, as the court will have seen, our concern is that the judgment in total is inadequate, and so it sits uneasily for me to necessarily say that there is copious reasoning to support that decision that the judge did make in respect of the mother.
Yes.
That being said, the evidence did point firmly in one direction overall, and the transcripts are available, but it may be that the court takes the view that matters should be considered.
Well, let's just hear from Miss Thompson, if we may. Miss Thompson, the guardian's position, please, because it was rather difficult to ascertain with respect whether or not this was support for a search for 6 months for an open adoption, and if that didn't work, then long-term fostering. I mean, what's the position now?
The position now, my lady, is that the guardian would still support a placement order for the child, but with a time-limited search of 6 months for a placement that could accommodate
well, is it possible to make a placement order time-limited?
My lady, no, but
so what is the guardian's position?
The guardian's position was there should be a time-limited search for possible adopters who could accommodate ongoing contact for the child and her mother, but in default of that being available, then there would have to be a reversion to a care for long-term fostering.
And that's her current position?
That's her current position.
So can you explain to me what order a court below, if we did allow this appeal, could make to accommodate that? My
lady, it would have to be care and placement orders with discharge, of course, of the mother's consent, and then the local authority would have to restore the matter at the end of the 6 months.
Well, how can you order that?
Order.
How can the court order that?
Well, my lady, I've seen it done by way of recitals with respect. I appreciate that may not be the most satisfactory way, but it's just trying to deal with...
Well, the recital would have to be by consent.
Yes, of course,
A court could not order, could it?
No.
A placement order to endure for 6 months only?
No, my lady. But the guardian's very strong view, my lady, and at the final hearing before His Honour Judge Scarratt, is that in her view it will be possible to identify adopters for this child.
So what is her position, please?
That there should be...
Quite apart from what may or may not happen, what is her position?
That there should be a placement order to give the child the opportunity of that permanency throughout her childhood and into her adult life.
Thank you very much. Okay. We're just having to transfer bundles because they've been cross-patched.
Well, I apologise, my lady. At least the court has bundles.
Not your fault.
No.
I should have probably checked that the court has a core appeal bundle, a supplementary bundle, which principally contains the transcripts, and the authorities bundle.
Yes, all right. I think My lady hasn't got the authorities or the supplementary.
But
because
they are on their way. Yes.
Thank you.
There should also be a loose case.
Yes.
Read DS. It was
Yes.
only that it covers such similar ground, and only 2 days ago, that I thought the court might be assisted by
This is
by
Lord
having.
Justice Peter Jackson's
It is,
case, yes.
and I know that Mr. Hall has provided an updated and referenced skeleton argument and a chronology to the court, which the court may have.
It's still dated 31st
31st
of
of
July.
July.
Is it the same but with references put in?
Yes.
It is, not
Yeah.
yes.
All right.
With the correct line spacing. I'm sorry about that.
Okay. So, Mr. Barnes, we've read your skeleton, obviously, in the grounds of appeal,
Thank you, lady.
and we've asked if there's any updating material. Is there anything that you need to amplify?
I think only by way of very, very short response, my learned friend Mr. Hall points to the issue around the foster carer as not having been the basis of the judge's judgment.
Yeah.
The judgment that appears within the core appeal bundle is at page 93, and it's right to say that that is now a judgment that has been approved and has had some minor revisions made by the judge, and that can be cross-checked because the full transcript appears within the supplementary bundle. But if the court is attracted by the observation made by His Honour Judge Scarratt and the line of reasoning that my Lord Justice Peter Jackson entertained, at the top of page 97, notwithstanding that there are comments at the previous page about a foster care placement breaking down with the foster carer or another carer, but at the top of page 97, you have the clear statement of the conclusion on the evidence that long-term fostering with the current foster carer will best promote welfare through the child's minority. That, in any event, forms part of the local authority's case that in analysing the options, the judge incorrectly viewed it as the likelihood that the current foster care would be available, and there is evidence within the transcript that that plainly wasn't what she was saying or committing to, and as matters have developed, was incorrect. It's also right that that sentence does point to a slight tension that goes to one issue again that Mr. Hall raises, which is that the judge refers to the welfare checklist without specifically saying whether it's the welfare checklist within the Children Act or within the Adoption and Children Act. Within the Adoption and Children Act, which we say is the appropriate framework, of course, any consideration of welfare is throughout the life of the child and not through their minority, and that is one of the critical points of difference between the two welfare checklists. So, my lady, we do say that the new information justifiably undermines one of the planks of the judge's consideration.
Yes. And this alteration to the judgment.
Yes, I'll take you to it. It's the middle paragraph of so there are two small sections. If on 95,
Yes.
there is a reference with a sentence starting, thus, as I've already said, adoption is not in the child's best interest, having regard to all the information before the court. In the original, that is a restatement of the suggestion that this was never an adoption case.
I'm sorry, I've got 95, but I can't say thus.
It's 10 lines down,
10.
thus, as I've already said.
Yes, I've got it now.
The other amendment to the reasoning is the central paragraph on page 96,
Yeah.
which starts, these are my short extempore reasons.
Yeah.
There is a mutually contradictory element in that indicates that the judge takes account of the guardian's view this is extremely finely balanced, But of course, earlier in the judgment, the judge has specifically said, and this is page 94, next to the bottom hole punch on page 94, let me return to the reasons why adoption has not been my first consideration. And I'm afraid I respectfully don't accept the point Mr. Hall makes that it's an inadvertent or clumsy phraseology. The judge adopts Mr. Hall's submission that it's not really finely balanced. It was never an adoption case, and that goes to the heart of our overall case, that there's been a preemptory exclusion of that as a real and realistic possibility.
And did you say that on 97, the reference to a specific foster carer is also an addition?
No,
That's always been in.
That I believe has always been in, but if my lady has the supplementary bundle.
Yeah.
Apologies.
Page.
No, apologies. So it's page 201. And on to 202. That reference to the specific placement does seem to be an addition. Apologies.
So that is an addition, isn't it?
Yes.
See, in page 25, 201, the penultimate full paragraph, it's whether it was with.
Yes.
Yes. I see.
And again, it's right. In the correction,
Yes.
those two contradictory elements are now in parallel in the final approved version,
Right.
which goes, I respectfully submit, to the perhaps a degree of incoherence and retrofitting in the judge's overall analysis, as it's now in approved form before
Yes.
the court.
Yeah.
My lady, addressing it briefly, this was a case, as the court will be aware, where there had been two sets of care proceedings. There had been an initial disposal with a return to the community under a supervision order with the mother, which had broken down. The proceedings then lasted approaching 2 years, which is consistent with some of the unacceptable delays that sadly have arisen recently. And the overall submission is that with a proposal for an adoptive placement properly before the court, and with momentous decisions to make for this child, the judgment and its analysis, it is so plainly deficient that it cannot stand. And sadly, given that delay is obviously a very significant concern, leads the local authority to accept that on disposal of this appeal, and unlike in the case of REDS that the court's brother and sister judges were dealing with, it is not possible for the court to substitute a determination. And the reality is that the adoption welfare checklist, which does appear within the authority's bundle to assist, requires the court to consider all of its powers. That includes giving consideration to the types of powers that might unusually be used to secure contact post-adoptive placement.
Yes.
That appears nowhere in the reasoning. And it is a real concern, my lady, to highlight in the supplementary bundle at page 79. The Guardian invites this court to give some guidance as to how post-adoption contact orders might be...
Yes, well, it's not going to happen, realistically, is it?
Well, my lady, I put before the court and included the Court of Appeal consideration of that statutory framework, but it isn't a case that can possibly be given. What I would submit respectfully is that the court does now have the transcript of His Honour Judge Scarratt's comments, and for a court, the obligation is to give proper, temperate, judicial consideration to all of the powers that are available, and to intervene to say that the prospect of an open adoption, and this is the middle of the page, is complete rubbish. Further down by the hole punch, that it's frankly woke, unrealistic. I've never heard such nonsense.
This is all in your skeleton, of course.
Yes, it was only that. I think that if the court is to give any steer, it is that where there is coherent evidence before the court from both a local authority and a guardian that an open adoption is one that should be given active consideration as balancing a need for permanence against the need for retaining a level of contact and a relationship with a birth parent, that should be considered properly.
Well, and the way that would be considered is not with respect to Miss Thompson by saying a recital necessarily, but an adoption order with contact.
And of course, my lady, the observation I make is that, of course, the local authority's care plan, which can be endorsed by the court, can include specific provisions as to the local authority's intention to search for an open adoption with adopters prepared to consider direct contact. That care plan is also the vehicle which could include, for example, the local authority's commitment to a time-limited search and a plan, if that search is unsuccessful, to give consideration to applying to discharge or revoke the placement order. And that's, in my submission, the framework by which the court can endorse a care plan that gives real teeth to the need to search, without descending into recitals that I know are increasingly not in vogue, especially with this court and the lack of clarity that provides as to whether they are properly enforceable provisions or not. But the care plan is a basis on which that could be achieved.
And it would also, therefore, to be quite clear about this, if the care plan did contain such intention, and I'm not necessarily just talking about this case, but unless that expression of intention was given completely mana fides with an intent to deceive the court, it wouldn't thwart subsequent actions if they became necessary.
No, and of course, as Mary observes, there are two sets of powers within the Adoption of Children Act that relate to contact provisions. One can attach contact orders at the placement order stage.
Yes.
But, of course, the reserve power is the making of an order in the context of an adoption order application.
Yes.
And the Court of Appeal authority suggests that it would be unusual for a contact order to be imposed against unwilling adopters.
Yes.
But it doesn't negate that possibility, and it says that it is ultimately a welfare decision on the specifics of the case. And of course, in this case, if we had the situation that the local authority was actively searching for an adoptive placement that was open to that future contact, and that was considered to be in the child's welfare interest, then that may well be a basis on which the court might consider exercising those powers. But there is, in reality, no suggestion of any bad faith, no sustainable argument that there was any deficit of the likelihood that the local authority would, in good faith, seek to implement the care plan.
No.
Of course, there is a balance to be struck if that proves not possible as to whether you seek to amend the care plan or revoke the placement order, and where that balance lies, that of course would need to then be given active consideration. And
Amendments of care plans don't have to come back to court, do they?
well, I think there are of course available remedies that are open to a parent as well, in terms of application to revoke a placement order and discharge a care order. And whilst the point was made in the course of the hearing that the mother may have some difficulty in functionally exercising that, my lady will be aware that there has been an expansion of the scope of some of the legal aid provisions to include applications under the Adoption of Children Act, which may assist. And of course, mother, as with any parent within care proceedings, will generally leave those care proceedings with a pre-existing relationship with a solicitor and a firm of solicitors, who at least may be a port of call. And of course, there are inbuilt protections through the independent reviewing officer procedure to allow ongoing scrutiny of both the care plan and its implementation.
Yeah.
But my lady, the essence of my submission, without wishing to detain the court longer than it should, is all of these matters should have been given careful and proper consideration by a judge in exercising this decision, not by adopting a hyperlink solution, as the Court of Appeal has deprecated, the emphasis on nothing else will do, and the identification of something else that will do. Mr. Hall praised in aid that this is an experienced family judge, and that should in some way remedy or ameliorate some of the deficiencies in the judgment. Respectfully, I say it's the other way. This is an experienced judge who should be more than aware that this analysis and consideration was plainly deficient.
Is this Honour Judge Scarratt still the DFJ?
No,
No.
I think it's Her Honour Judge Davies.
Right.
And my lady, just dealing, I'm obviously entirely content to expand on the reasons that we say the appeal should succeed, as far as that assists the court, but it may not require more. In terms of disposal, my lady has my fundamental position, which is that there was a coherent evidence base to say that it wouldn't be safe for the child to return to the community with the mother. Whether the court decides that in setting aside this judgment it is sufficiently deficient that all matters would need to be considered again is a balance for the court, but may extend matters marginally, and obviously I suspect there would be a need in those circumstances for the matter to be before another judge rapidly for case management towards a listing that must, in my submission, be prioritised to ensure that it's heard as swiftly as possible.
Who's the family presiding judge for the Western Circuit?
It had been Mr. Justice Williams who was responsible for the South Eastern Circuit, but I believe there may be a new presider who's been appointed. So apologies. If that indication is wrong, then I will try and update it and correct it. And Honour Judge Davies, I believe, is the designated family judge, and nods from those who are more frequently in Kent than I am.
Right, thank you. Yes, it's Kent, sorry, it's not the Western Circuit. The only other thing I've got for you before either my lord or my lady may want further questions answered. How did the information from the foster carer come before the court? Was it an email? Was it merely hearsay evidence? How did it come before the court?
I think, my lady, what occurred was obviously the judgment was delivered on the 15th of May. Curiously, at that point, that order didn't include the dismissal of the placement order application. That took place at the hearing in early June. There was then a further hearing because the judge wanted further revisions to the care plan that took place in early July, albeit the order in the bundle, I think, is misheaded. And it was at that hearing that that information was provided. I'm afraid I don't know the genesis of it, save that those were obviously discussions that had taken place between the foster care and the local authority in the course of settling the
Yes, but
foster
of course
placement.
you weren't counsel below, were you?
No, I didn't appear below, unlike my learned friends, and I don't believe that Mr. Hall was involved in the hearings in June or July. Miss
No.
Thompson may. Miss Thompson was, I think, there in June, but not in July. If you excuse my background.
Yes.
What I'm told by the social worker who instructed me today is that there was an email that was provided by the foster carer. I haven't seen the email, so I can't go beyond the instructions, and so I'm approaching it with that caveat. That's her understanding as having been.
Was the email put before the judge?
I believe. I think it was. The indication was it was reported by the advocate attending on the July hearing, rather than the email itself being before the judge.
Right. Okay.
So I'm content to try and seek that email as swiftly as.
Well, I'm just interested to know how the information came before the judge.
Well, I think in terms of the settling of a plan for long-term foster care.
Yes, I understand that, but it was new evidence, effectively.
Yes.
After he'd given his judgment.
Yes. I will endeavour to clarify and have the email sent to me rapidly.
As I understand it, he'd already handed down his judgment.
Well, the extempore judgment was delivered. I think actually the approval of that version post-dated the hearing in July.
Yes, so he delivered his judgment
Yeah.
extempore, subject to corrections.
Yes.
So he couldn't change the outcome at that stage, could he? So I'm just wondering how the email came to him. I know that he's asked that this court have it, but I'd be surprised if it wasn't actually given to him rather than just reported.
Well,
and I hope it was disclosed to the other parties.
I'm afraid I wasn't at that hearing, but that will need to be checked.
No.
The only other final matter to indicate is this: there was obviously a short decision given with what was stated to be summary reasons. This court has previously deprecated the giving of reasons that are then expanded conditional upon a party dissatisfied requesting fuller reasons. We do say that that's not an appropriate principled approach for the court, that there should be a full judgment that is delivered, and that is what is required on behalf of the child. But if there is to be shorter summary reasons given and a perfected judgment, it is incumbent on the judge to make sure that there are appropriate steps taken, that process can be fulfilled. And that includes directing, if necessary, transcripts and including some indication as to the timeframes. In this instance, if there was that intention, it wasn't reflected in order, it doesn't appear to have been absolutely agreed and understood the basis of it, and the court took no steps to seek to perfect or add to that judgment. So there are, in my submission, there are, of course, pressures, significant pressures on family judges in resolving cases, and there is latitude as to what is precisely expected in judgments, but there must be a focus on ensuring that if there is a delay in full reasons, that there is a proper process by which those are provided in a hopefully timely fashion. And as it happens here, in fact, whatever the judge's intention, he hasn't substantially altered, amended, expanded those reasons. And we say clearly that this falls into the category of cases where the reasoning is so deficient that a process of clarification wouldn't be adequate to manage matters. Melody, I'm not sure I can assist further. I'm very happy if there are other areas, but
No, thank you very much,
Thank you.
Mr. Barnes. So, Ms. Thompson, let's hear from you next, since you support the appeal.
My lady, the Guardian hears the arguments obviously advanced by the local authority, but equally has considered the skeleton argument advanced on behalf of the mother, that if this court is minded to permit this for hearing, it is, one can understand, difficult to see perhaps how the court could not revisit the entirety of the local authority's applications, again, that is to consider the making of a care order and or the making of a placement order, my lady. Equally, the Guardian very much takes into account the fact that this final hearing is some months ago now, and that has been significant in terms of the child's life, who is approaching her next birthday very shortly, and also has a significant change coming up next month in terms of education. The Guardian would also wish very much to be fully updated as to what has happened for both the child
Yes, Ms
and the mother
Thompson,
since then.
I can understand all this, but can we have your submissions on the appeal?
Oh, my lady, forgive me. We respectfully adopt, obviously, the arguments advanced on behalf of the local authority, but in particular, in behalf of the child, the fact that, unfortunately, there was not a full consideration given to what her needs are going to be in terms of both the welfare checklist under the Children Act and also the Adoption and Children Act, and not only during her childhood, but beyond that, and thereafter a balancing of her needs in terms of considering all the options available for this child for her long-term future care. The Guardian was particularly concerned that there's no full risk analysis, with all respect to His Honour Judge Scarratt, and that's something, my lady, that has chimed throughout the professional reports that were available to the court at the final hearing in May. In particular, the evidence, of course, of the child social worker, the evidence of the independent social worker, Miss Wetherall, and, of course, the evidence of the Guardian, Miss Mitchell. And, my lady, whilst Miss Carpenter had only been allocated as social worker for this child since September of last year, Miss Wetherall had reported in the first set of care proceedings in relation to this child, and the Guardian had been her guardian in those proceedings, and therefore had a very good knowledge of the full background and, of course, working relationship with the mother too. And it's right, my lady, to say that they all pay tribute to this mother and the huge effort she made to try and get support for herself, to have counselling, for example, the courses she went on. Sadly, the ultimate conclusion was that things simply hadn't progressed sufficiently in a number of years for there to be any confidence that this child could be safe in her mother's care. And particularly prayed in aid were the concerning incidents in January and February of this year, which happened even while the child was in the safety of a mother and baby placement. And, my lady, I can take the court specifically to the references for those if they exist. But
well, your point is that the judge didn't deal with them.
he didn't, my lady, no. And we did provide very full written submissions to the court for our closing and a note on the law. But they are not even referred to within the judgment. And I very much adopt, if I may respectfully, my lady, Mr. Barnes's point that we know the family judges are under huge pressure, and we particularly see that in Kent. I'm sure this court sees it from the courts all over the country. So I hesitate to criticise in any way such an experienced judge. But unfortunately, the judgment did not identify what, in the Guardian's respectful views, were the really important factors for this child, with this child's background, and with the very lengthy state involvement this child has had even since pre-birth.
Yes.
Unless I may assist further, my lady.
No, thank you very much, Miss Thompson. Thank you.
My lady.
So, Mr. Hall.
Yes, thank you, my lady. You have, of course, a fairly full skeleton argument in opposition to the appeal.
Yes, thank you very much for that.
And I'm sorry that I got the line spacing wrong. I was reminding myself of the practice direction and where you have it now. My lady, I'm going to start, if I may. Please stop me if I find myself repeating the information in my skeleton argument. But of course, since that was submitted, we've had the transcript of the hearing. And if I may, I'm just going to expand on some of the points that are made in the skeleton, having seen and referred to the transcripts. And I'm going to start, if I may, with the email to the court. So I'm going to deal with that first, and I'm going to touch, I hope succinctly, on our response to the main criticism of the learned judge's judgment. I, of course, accept that the email, to this unusual step of the judge emailing the Court of Appeal is a significant communication. I set out in my skeleton argument, paragraph 22, a number of the points, but I will, if I may, look at what was said in the evidence on this issue of, if you like, the longevity of the proposed foster placement, because it's my overall submission that, in fact, the evidence before the court, and indeed consistent with the learned judge's judgment, is that, in fact, there was no guarantee that the child would remain with the foster carers for the remainder of her minority. I'm going to start with the evidence of the social worker, and in the supplemental bundle we find the transcript of her evidence. And the page number is 90. The social worker was cross-examined by, I believe, counsel for the child as to the current placement. And we see about 2/3 of the way down the page the exchange. In terms of B, staying in long-term foster care, she was asked, is there any possibility that the current foster carers might be able to continue as long-term? To which the answer is very clearly not long-term. It's been put to them, says the social worker, but it's not something that they would consider in terms of long-term foster care. There doesn't appear to be, in other words, any ambiguity about this from the child's social worker, who I'm sure the court will assume had up-to-date information. The foster care's evidence begins in the supplemental bundle at page 106. And at page 110, again, she's asked a number of questions. In fact, I think by the local authority advocates and then by me about her intentions. At the top of page 110, the foster carer makes it very clear that they would be happy to have mother and child remain with them, because we see elsewhere in the transcript that is what they do. That appears to be what they want to do and what they like doing. And then at the top of page 112.
And we read on, don't we? Because Judge Scarratt says no, but just so I've got that right. So all things being equal, you're happy for them too? Absolutely. We've never had an issue with mum and daughter living in our home, and all of us are very happy together. Yes.
But, my lady, that's in the context of them both remaining in the placement.
Well, no, it's about her leaving Kent. So you're leaving Kent. That's due to personal issues with KCC. Nothing to do with this placement.
Yes. But they were leaving. That they were in-house. My understanding is they were in-house foster carers. They were leaving to an independent agency. So they were. I mean, geographically, they were remaining where they were.
Yes, of course. But they're saying it's not their decision whether or not the foster placement continues.
Absolutely.
Although they would be happy.
They would be happy to keep mother and baby and child with them.
Yes.
But of course, the issue, as we will see, becomes well, what happens if it's just the child?
Yes.
Which is what I'm coming on to, and she is asked specific questions about that.
Thank you.
And we see, I think it's at the top of page 112. Forgive me, at the foot of page 111, in terms of the other option, where mum says she would like her daughter to stay with you as a long-term foster placement, is that something you can consider? Again, is the answer, it's something we would have to discuss with KCC. We'd be happy for B to stay in placement with us, and it's been discussed that should B be adopted. Would we be happy to care for her? We have agreed, yes, we would. We would not wish to let mother or B down, should that be the decision. And then there's some clarity there, a couple of lines further down. Would you not happy for B to continue to be fostered by us until she found, forgive me, we would be happy for her to continue to be fostered by us until she found an adoptive family. And then we cannot commit to 18 years of caring for B, and I think it would be wrong to say that we could. We are older and we are parent and child foster carers, which of course chimes with the previous answer when she said that's what she would
Who's
be.
Miss Barter?
That's the advocate for the local authority.
Yes. Yes. The local authority.
And then
Did the foster carer answer Miss Barter?
forgive me.
Thank you. In fact, that answered my next question about how long could you care for her. So essentially, it would another 14 years, and you're saying you cannot commit to that. I have no further questions. So, did she wait for a response?
There's no, my lady, I don't know.
No.
I can't remember.
All right. Thank you.
My lady, I then cross-examine the witness, and I tackle her about this as well. And if we fast forward to the bottom of the page, and I go through to make sure that she understands what's being asked, and you'll see how that passage develops. And at the bottom of page 114, I put to her, but I mean that there is a provenance to the question, and I'm not going to read it all out, but if the local authority came to you and said, I asked, well, look, this is the court's decision, it's long-term foster care. She then says, that would be something I would have to discuss with my husband's son and the mother, and B, you know, it's a huge commitment.
Yeah.
So, for completeness, my lady, the Guardian gave her evidence. That's at Supplemental Bundle 159. If one looks at the answer about a third of the way down, beginning with the problem with the foster carer is, when I've spoken to the foster carer, she is a parent-child placement. She is moving, as you said, agencies that will have an impact on costs, but it shouldn't be about costs, it should be about B's needs. The foster carer did have the other little girl quite a long time, but she does help to move children on. That is her remit now. That is what she prefers to do. So I suppose just pulling together all of those threads, there's certainly in the evidence, I mean, I appreciate that what this court will be concerned about was what was the judge thinking when he gave his judgment and when he wrote his email. But certainly the evidence before him was certainly not a picture of a foster carer really getting anywhere near to committing to caring for the child long term.
No, but as you say, Mr. Hall, it then makes it even more worrying that the judge thought he was hearing different things.
Well, my lady, may I know that's a concern, and I'm not going to say it isn't. But just looking at the terms of the judgment, and this is something which I deal with.
The new judgment or the old judgment?
The judgment that we have.
In the core bundle?
In the core bundle.
Yes. And do you want to take us there now?
I'm going to take you there now.
Yeah.
Just,
Okay.
just give me this. So I'm looking in the core bundle at page 93.
Thank you.
It's a passage that we read, I think, probably repeatedly in the Scarratt arguments that you have, but it's an important one. I'm assisted by, says the learned judge, the extremely good witness yesterday, who made it clear that Bella, can stay with them provided it can be agreed with the local authority and whatever agency she is going to work with. Now, just pausing there, I take my lady's point about that being a disconnect between that and what he heard. But nevertheless, how it's expressed as a hope rather than an expectation, and obviously I stress that. The second point of the judgment is at page 94. The recognition by the learned judge in the fourth paragraph is acknowledging, if you like, it's a point of universal application, but he is recognising that the risk of breakdown.
This is beginning with the name of the child. B,
Correct,
as I say, is almost
correct.
all, yes.
And then at page 96, and I'm looking at the third paragraph after the quotation, beginning, I have, of course, taken account. The fact at the end of that short paragraph, the fact there is such a close bond between mother and daughter, and that B is rising 4 years, will, in my judgment, help to make the placement, whether with this foster carer or elsewhere, stronger and less likely to break down.
Do you agree, Mr. Hall, that although that was in the original judgment or note of judgment that we've seen, that that part of the judgment on 97, the top 3 lines, that does seem to have changed? Do you agree?
I have separately a note of judgment where I've yellow highlighted the bits that are different, and I'm afraid mine does not have that bit yellow highlighted. That's not to say that it isn't different. I'm perfectly content. I mean, the 2 documents will tell us, and I'm sorry, I haven't got the original.
The sentence I have concluded on the evidence doesn't seem to be there in version 1.
Right. Well, my lord, of course I accept that. I must have missed that. I thought I'd spotted them all. So yes, I accept that.
Yeah.
So what the judge isn't saying is that he expects the child to remain for the rest of her childhood at this foster placement. It certainly wasn't the evidence. Drawing all of this together, it certainly wasn't the evidence of the foster carer or 2 other very important professional witnesses who would have known the lie of the land that she could. And looking at the terms of the judgment, the decision, in my submission, clearly based on appreciation of the risk that she may not remain there. So therefore, then just turning to the email, it's puzzling. I submit, given everything that had gone before. The email itself, it lacks detail. It's written nearly 2 months after the learned judge had heard evidence.
Did you see it?
No. No, I just...
And by this I mean the email that contained the information that was handed to the judge.
No. My understanding is I wasn't there, that it was explained by the advocate for the local authority. And I
I've sent it to my lady's clerk in the meantime.
Right, okay.
Have we? Okay.
Thank you.
Well, I haven't seen...
When you say the email is puzzling, you mean the email to this court
I am,
from the
exactly.
judge? Yes.
Precisely.
Yes.
I'm so sorry, I didn't make that clear.
No, it's my fault.
I mean, I haven't, apparently an email's arrived, obviously I haven't seen it, but I have to make the point that there is, I mean, we don't have exact or even general idea about the provenance of the information, how it was elicited, who said it, in what context, how 5 years was arrived at, and so on. And there is no, I mean, I'm not criticising the authority, but there's no application for further evidence to be adduced at this hearing to explain any of that. And I just make the point that it's not consistent. What he says is not consistent with the decision that he made with the evidence fresh in his mind. I mean, had it done so, then that email would have more traction in my submission.
I'm sorry, I don't follow why it's not consistent with the evidence that was before him when he made
the only point I'm making, my lord, is that the evidence that he heard and the way that he framed his judgment on an interpretation that I invite the court to appreciate is rather out of kilter with his comment in the email to this court, that his decision might have been different had he known that the child could only remain at the current placement for 5 years. In fact, what I would say about that is that actually the 5-year term, I mean, could on one interpretation of the evidence seem a bit of a result in terms of stability, compared with what was before the court.
Well, hang on a second. This is why the email might be important, and I still haven't seen it.
Yes.
Is the foster carer saying B can remain with us until she is 5 years old, or I will only commit to a 5-year term for any placement, or we are intending to finish 5 years from now, in which case we'd still have a child who is very much well short of her majority.
Absolutely.
And at a very crucial stage in her life, in terms of schooling, settlement, relationships, perhaps with her mother, perhaps with others. So, I mean, it's you say it's out of kilter with what the judge wrote to us, but I'm finding quite difficult this addition that we discussed just minutes ago, which we now see is an insert, which is inherently contradictory to the matters you've been raising, which would suggest that the judge hasn't read his judgment through again in full.
Well, lady, I don't think there's anything I can say.
No, of course not. But that's the difficulty that we've got, where the merits of this case lie. Mr. Barnes says, "Well, Luke, this is just such a deficient judgment." He's inviting us to throw our hands in the air and say it's just irredeemable, and it may have been made worse, quite frankly, with some of the clarifications he's made, rather than better. So
My lady, I appreciate that in one sense I'm on a bit of a cleft stick, because I'm saying there's an inconsistency here, or on one interpretation of it there's an inconsistency here in relation to what the judge is saying in his email to the Court of Appeal and what the evidence says and his judgment. And if I may, I'm going to get onto it now, because I don't think there's anything else I can say about the email to the court. I think I've said all that I can on the arguments about that. I say, obviously, for completeness, that there isn't enough there.
yes, I mean, I am a little concerned. I've just seen now the email coming in, and I've got it. And the terms of the email, we have the email train. So there's an email from the local authority to somewhat at Caldecott Fostering, copied in saying the foster carers who we're seeing referred to in the judgment transferred to your agency, indicated wanted to care for the child long term. However, within the court proceedings, foster carer said she didn't consider long term being viable. It would help us to understand clearly whether foster carers are putting themselves forward to care for child long term and what this may look like. Is this being proposed as foster carers, for example, or are they wanting to be assessed as SGO, special guardianship order carers? Alternatively, the view may have differed again since the initial discussions took place. This will be able to inform our PPM when arranged. Then we get Caldecott Fostering saying foster carers have made very clear maximum amount of time they would keep child for is 5 years. Already given their decision when asked about SGO, and this was no. The decision has not changed. Foster carers did not really agree with the court's decision, so they cannot commit to care for her until she's 18 or an SGO. I've emailed Natalie regarding placement planning. Foster carer did advise yesterday she'd been told that foster carer, forgive me, social worker would no longer be allocated. However, this meeting should have taken place 2 weeks ago, and then please see email below as requested. So presumably that was put before the judge. But it's completely new evidence. I mean...
And I take the point that, of course, a maximum of 5 years, that could mean 2 weeks. I mean, we don't, it's not saying 5 years. Is
no,
it?
But it's new evidence, and the fact is, these are court proceedings, and after a judge has delivered his judgment, it's, of course the welfare of the child is important, but there does need to be some structure to matters going forward. Nobody'd seen this, nobody had the chance to cross-examine it, nobody had the chance to consider it. I mean, it rather adds to the problems, I'm afraid, Mr. Hall. Speaking for myself, I can only speak for myself.
On the other hand, it seems to me that it's entirely consistent with what the foster carer said in her evidence in the first place.
My lady, yes.
If you actually look at that first passage in cross-examination that you took us to, it seems to me to be blindingly obvious that that's what she was saying. There's no mention of 5 years, but she's making it very clear that she's not committing to the child until the child is 18, however much there's a loving relationship between them. So I think that this new evidence that's come forward is just consistent with what the judge heard, and what's just sort of thrown a spanner in the works is the fact that the judge has added that sentence to the top of page 97, which suggests that he heard something completely different.
Well, it's worse than that, I'm afraid. It's the introduction of a special guardianship order. Where does that appear in the judgment, or consideration, or evidence? I mean, it really is rather baffling that this is thought appropriate. That's not for you to answer, because it's not your responsibility, of course. Sorry, Mr. Hall.
My lady, on the SGO point, there is, I'm sorry, I haven't got it right with me, but I will be able to find it. There is an exchange with the foster carer about SGO. And
certainly not in the judgment, is it?
It's not in the judgment.
No.
But again, consistent with
what my lady says, yes.
My lady, if I may, I'm conscious of the time, and I don't think really there's anything I can add to what I've already said, unless there's any particular issue, just in relation to the email to the court.
Yes.
So I'm now going to turn, I hope succinctly, to the issues, if I can put it like this, the main thrust of the appeal.
Yeah.
And it really centres on the learned judge's failure to undertake an adequate evaluation of the realistic options and inadequate reasoning. One senses there's a great degree of overlap in those arguments. What I don't do is pursue the course of action suggested in paragraph 41 of my skeleton, requesting this court asking the learned judge to give fuller reasons. I mean, he's done that. He's been given the opportunity. He's been asked to do it, and he's done it. And we have the result. My lady, the first point, I suppose the main point that I would wish to make in oral submissions, concerns, it was really an observation about the nature and the limits of the dispute as at the date of the final hearing. I'm completely conscious that quite a lot's happened since then. Not least, we've had a separation of mother and child and the views of the foster care and so on. But what I want to concentrate on is the lie of the land at the point of judgment. There were factual issues. And of course, in judgments, factual issues take up an awful lot of acreage. But those factual issues centred on the failings, the alleged failings of mother as B's full-time carer. And you may have noted from the transcript of the evidence that mother did dispute a number of those allegations, that, for example, she'd caused risk to B whilst in foster care. An essential theme of the investigation of those alleged and challenge to the evidence related to that aspect of the case. How frequently were nappies left out? Did she lie about seeing her work colleague? That sort of thing. Those issues about which there is very little, indeed really any, evaluation and analysis, mainly sanded in the debate about whether B should be cared for by my clients in the community. The threshold criteria had been agreed, so there wasn't any factual issue about that. And of course that decision went against my client. It's not something that the local authority complained about in the appeal. In relation to the aspect that the local authority are appealing about, in other words, the debate about placement order versus long-term foster care, those factual issues, whilst having some importance, weren't so important. They had some relevance, but not central relevance, perhaps. What evidence did the judge have before him dealing with the placement plan against long-term foster care? One is, of course, dealing with, it seems an obvious point, one was dealing with the abstract. B had never lived in foster care on her own at that point, and of course she'd obviously not been adopted. So one was dealing with the ideas, the predictions. And I may be guilty of oversimplifying the arguments, but the main evidential analysis for and against each option, as outlined in the evidence, were those of mainly general application. And this is helpfully encapsulated in the social worker's final evidence, where she sets out, as is often the practice in care cases, where there's a table of realistic placement options, where the well-known and powerful factors for and against adoption are set out. And if we look at the core bundle at page 238, we see that set out. And it's in tabular form, and there is really nothing. These are all very important features that the court must take into account. I can't begin to suggest otherwise. But they are well known, and I suppose my point is that we can rely on and trust that this very experienced judge, who already observed was for many years the designated family judge for Kent, would have been aware of these. He has referred to them, interestingly, in the submissions. And in the local authorities' submissions, it's interesting how it's put, and there's no criticism of the way in which it was put, but I'll read, rather than get you to turn it up, I'll read it out. It's in the local authorities' written submissions, but for reference purposes, it's supplemental bundle 219. What the advocate for the local authorities says in her final submissions is this. C206 to 207, which is the pages that I've just referred you to, sets out the pros and cons of each option. The court will be familiar with the arguments as to the arguments for and against foster care as opposed to adoption, and will not be rehearsed at this juncture. There were some case-specific factors which were clearly a central feature of the evidence. And those were that, in this case unusually, that the child rising for had spent the whole of her life with her mother. That they had great love for each other over that span. And the guardian's evidence was that this was an unusual feature. She accepted that in her oral evidence. There's no need to stand it up with the references at supplemental bundle, page 164.
But is it right that we should look at this without being, as it were, au fait with the context, which Mr. Barnes put to us quite forcibly before he sat down, which is this is judge who unfortunately was saying things during the closing submissions which went beyond a discussion. They were stating views as to wokery and
Yes.
the like. And therefore, by saying these factors are well known in general, I'm going to invite you in a moment to take us to the judgment where he considers these factors.
There are 2 points there. The first is that the woke comment. I'm not going to suggest that was a. I'm not going to try and defend that comment, but it was during the evidence. In fact, I mean, I know that doesn't make my argument any better, but it was during the evidence. I mean, just pausing and let me deal with that, because it's clearly something I need to deal with. Some judges do say things during the case which gives an idea about what they're thinking at that particular given moment. And it happens. But I of course, argue that doesn't mean that he approached his judgment with anything other than an objective, fair approach, which in a moment I will address you about briefly as to the important factors that he did take into account.
Yes, I accept that argument, but you will have to demonstrate to me that the judgment does show that having made that comment, he then went on to consider and weigh and analyse in the way that he should if he was bearing in mind the welfare checklist under the Adoption and Children's Act.
Yes.
Because that's the difference. I do accept your argument, though, that it is possible for a judge to say, well, you know, at the moment, let's be realistic about this. And there are ways and means of doing that. But you then have to go on to show that you have had an open mind. And we go back again to the problems with the judgment, I think, Mr. Hall. So I would be insisted by your help on this.
My lady, I will deal with that. Well, let me deal with it now.
Yes.
I mean, the point is that I accept. I can't create words in the judgment that don't exist, obviously. And there is a lack of analysis. I accept that. But my point is that given this was a debate about the abstract, a debate about arguments, almost all of universal application.
Well, I don't think that's fair. I don't think that's fair, because you've just spent quite a few minutes rightly telling us that this wasn't actually one of the run-of-the-mill cases. We've got a young mother who's done her best, who seems to be doing very well. So, I mean, you can't have it all ways.
No, what I mean is that he does touch ground on the particular factors. Forgive me that I didn't develop my argument quick enough. He does touch ground on the factors that, if you like, are particular to this case in his judgment. But I concede what he doesn't do is set out the important arguments of general application. And I know that my learned friend for the local authority criticised him for that. And I don't seek to completely refute or argue against that criticism. So that's the point. But the learned judge does deal with the subjective points that were relevant in this case. When he specifically refers to, and it's supplemental bundle page 94, paragraph 4. So we're looking at the transcript.
Yeah.
So if you like, these are the passages that I rely on particularly.
So 94 of
So
the...
SB 94, paragraph 4. where he specifically refers. In that
Sorry, I don't think it's the supplementary bundle.
I think it's the core bundle.
Oh, I'm so sorry. I'm so sorry. It's the core bundle. I'm so sorry. It's the core bundle.
Right. Thank you. Right. Yeah.
And it begins, is the paragraph beginning with the name of the child. B, as I say, is almost 4. He specifically refers in that paragraph to the risk of breakdown and constant disruption and possible harm. And then the last part of the page he refers to the difficulties, forgive me.
It refers to the excellent foster carer being able to look after and care for this child.
He refers. Forgive me for a moment. He refers, forgive me, at page 96. It's one of several references, but he refers to the very close bond between mother and daughter, and that implicitly that they've been together, I think expressly elsewhere in the judgment, they've been together for all of that time. That will help with the stability in the foster placement, and that a great deal of evidence dealt with in the submissions, in that this is a mother who interacts very well with all around her, and it has positive relationships with the social work team and the foster carer. And so that is a particular feature of this case that he does touch ground on. And he refers, I mean, it's a general point and an important one, at the bottom of page 96 to the stigma of remaining in foster care. I'm very conscious that I make all of these points in my skeleton argument. But these are, if you like, the more important. But he doesn't go, as I've already conceded, exhaustively through the sort of table of pros and cons. But he does, in my submission, in the way that I've pleaded, touch on the most important, including the subjectively important aspects of the evidence in the case, being the fact that there had been no separation for 4 years, and the fact that there was a great love and bond between mother and child that would affect the chances, would affect the child if there was permanent separation and the sort of very limited contact that was being countenanced, I think, once a year in the event that an adoptive placement could be found. My lady, the judgment is there, and I don't think that I can really expand on the reasons that I say and which I set out in my skeleton argument and the submissions that I've already made in relation to the analysis. Looking at, I suppose, drawing it together, I mean, it doesn't take very long to read the judgment, but looking at this decision by this experienced judge, I submit that the parties knew what the decision was, of course they did, but more importantly, they knew, reading this succinct, but necessarily specific to the facts of this case, they knew the reasons for him preferring one option above the other. My lady, I accept that there is, I can't really square the comments, and I don't try to, that the learned judge makes about it being that it was never an adoption case, and that it was a finely balanced case. I don't think there's anything I can really add to that debate. I accept that those are two different things, but it was certainly the professional evidence of the guardian and the local authority, as encapsulated in their written submissions, that it was a very finely balanced case. Just a couple of points that have been advanced by the local authority in criticism of the judge. He's criticised, in my learned friend Scarratt's argument, for what is described as a wholly speculative consideration, being the potential detrimental effect on B in the event that she were to have younger siblings who are living with their mother. I would submit that was not, I mean, it was obviously a prediction that this was something that might happen. It was something that the Guardian was specifically asked about and gave oral evidence about, and the references, Supplemental Bundle 165. The Guardian acknowledged that there was a strong possibility that, given mother's age, her maturation, and with the correct support, she could look after future children. And the Guardian agreed that was a proper consideration in the debate as between placement order versus long-term foster care.
I find that quite a difficult concept to understand, actually, because if a child is not living with mother and she sees younger siblings are, does it matter whether it's a placement or a long-term foster care that will make her feel that she's different from her siblings?
Well, I suppose to develop the point, in the event that it was something else that the Guardian was asked about, that this, because I think the Guardian's comment was she's not yet ready to assume the care of her daughter. So there was a whole thread of evidence about, well, that must be a possibility. Maybe not at the moment, if the court is against mother's main case that she should be able to look after.
Yes, but we look at the judgment which says there's no way that the child is going to go back into the community with mother.
The judge does say that, but intriguingly, at the end of the judgment, he does consider the possibility of an...
Yes, it's another difficulty, I'm afraid, of the judgment, isn't it? That it's just not consistent. There's no one thread going through it, I'm afraid.
My lady, I don't think that I can develop the point any further.
So that's the younger siblings point.
That's the younger siblings point. I suppose, just to sum it up, there was an evidential platform for me to make that submission.
Of course.
I don't think that I can add anything to what I've written in my skeleton in relation to the treatment and discussion as to the legal principles, other than we now have it was an agreed document setting out the law. It wasn't something that was contentious. I mean, that's clear in the transcript of the submissions.
Yeah.
And so that mitigates, in the event that the court is persuaded that there isn't much or enough discussion and analysis of what the legal principles are, it mitigates that criticism. That's all I would say in relation to that. My lady, in relation to the criticism as to the adoption contact issue, again, I deal with this in my schedule. There's not much I can really add to it. We know from the transcript of the social workers that, and I asked the social worker at some length about this in cross-examination. Well, what is, to summarise, what is the local authority's plan in the event that you can't find somebody who is open to the idea of an open adoption, which is rare, something which is, I think, acknowledged by the President in that interesting document produced on behalf of the child in the supplemental bundle. And the response was, well, we might then look at a closed adoption if we can't find anyone. That possibility was raised by the social worker. And in the local authority's final submissions, again, the reference name turns up, the reference is the supplemental module 219. The local authority is suggesting that there be direct contact post-adoption. Of course, this will not always be appropriate and will depend upon the circumstances of each case. So there was certainly ambiguity. I mean, what the local authority weren't doing is saying, look, Judge, make a contact order that will last into placement, which will only come to an end when the adoption application is made, and then at that point, the court can consider whether a contact order should be made. That wasn't the local authority's thinking.
But it didn't need to be. It's what the judge should have been thinking, though. Surely, if he'd got to consider all of the options, and he was convinced that this was a case that was centrally turning upon contact, but he'd given thought to everything else, he's surely got to say, well, I've considered whether or not a placement order with a contact order should be made. And I either think that will work or it won't work. But he's got to show that he's thought about it, hasn't he?
Well, my lady, he doesn't. It's not dealt with in the judgment. I think that's as far as I can go.
Right.
I hope you can understand why.
Of course I do.
My lady, I'm going to now leave those issues, and I'm going to turn now to, unless there's any particular issue that I haven't covered, that isn't covered, no. Then it may be that the court doesn't need persuading, but in the event that the court has disquiet about the level of detail and analysis in this judgment, and of course I accept it's a leitmotif in my written submissions and my oral submissions, but of course I accept there is that possibility. Then I do submit for the reasons in my skeleton that one can't sort of separate out, the milk from the tea. It needs to, if it's going to be remitted, and it must be, then I would submit that it's not going to affect the time estimate particularly, because my client's abilities as a parent and her ability to spend time with her daughter are going to be relevant on the placement application as much as the care point. It may be that the evidence, and I don't know what that evidence is, and I've only had an opportunity to speak with my client briefly this morning, but it may be that the evidence that is put before the court at a rehearing, if that's the court's decision, if the court's decision is to allow the appeal today, it may be that evidence is going to make the issues much more straightforward. I don't know. For completeness, my client told me in our discussions today that she had a lovely time with her daughter a week or so ago with the foster carer. It was all fine. I think they had a day out anyway. And so the relation was, what she was telling me is positive, but of course...
There's been a rapprochement.
Yes. I haven't got quite to the bottom of whether there needed to be a rapprochement or not. Anyway.
Yes.
But so I do say that. I don't think otherwise that I can improve on the points that I made in my skeleton on that issue. So, my lady, I'm sorry I was slightly longer than I thought I might be, but...
Not at all. You've been very, very focused, if I may say so.
Thank you.
Thank you very much, Mr. Hall.
My lady, there are only a short number of very, very, very brief points. First, my friend refers to the note on the law. It is right, there was an agreed note. What is notable is that specifically includes reference to the case law that a judge shouldn't use, nothing else will do as a shorthand hyperlink to disposal, and yet that's precisely the error he fell into, so it's difficult to read in the note on the law as having had any discernible positive impact. In terms of the case-specific issues, my lady's obviously referred to the comments about wokery and nonsense and so on. Of course, where that grounds, in my submission, the judgment, is a lack of any real proper consideration of the potential advantages of open adoption if it could be achieved in terms of the balance of stability and maintaining a relationship. In fact, towards the top of page 95 in the judgment, open adoption is presented only as a problem because that's what it should be and it can't be achieved. So that's that characterisation of being able to stop contact at a whim is demonstrative of the way in which those comments feed through to the overall approach that was inadequate and failed to consider the totality of the court's powers.
Just on this point, Mr. Barnes, as I understand the law, a court considering whether or not to make a placement order is not necessarily dependent upon the needs of the child, looking at the prospects of achieving a placement. It's a placement order is, will this child's welfare throughout their life be better assured by the making of a placement order leading to adoption on the premise that that's what will happen?
Yes.
It doesn't always happen.
No.
So that this is a bit of a red herring, isn't it? Unless he's going to say, effectively, I've got to look at contact. Because unless it's open adoption, and that's one of my options, but it is really extending boundaries to say a judge has got to be satisfied before making a placement order that an open adoption will be available in the county of Kent.
Well, I certainly agree that the geographical restriction is one that comes from the judge and has no grounding. In the DS judgment, the point is made at the top of page 7 about uncertainty about the prospects of finding a placement aren't a reason not to try if it's in a child's interests. Yes. And so a good faith effort to search for an open adoption, you at least have to consider then whether there's sufficient welfare heft in making that attempt to consider matters. And one of the points I was going to turn to is that one matter that's entirely absent from the court's judgment, and that is something that surely must be considered, is what's the detriment to the child of a time-limited search for an open adoption, where my ladies and my lord have seen the evidence from the foster carer who is actively saying, I will keep this child until there is an adoptive placement, and evidence from the guardian that they are well experienced at helping children to move on, for example. So if it can't be achieved, and there is a placement in foster care that is maintained, there would have to in any event be a matching process for a long-term foster placement. So again, that's about getting into the balance on the particular circumstances of the case and a proper grounded analysis of the pros and cons, which is absent. And my learned friend points to the judge's purported engagement with the case-specific details and refers to the judge's comment that the close bond between mother and daughter might help with the stability of the foster placement. That springs from evidence that goes to this is unlikely to be a mother who would actively undermine a foster placement, which might be said to be one potential issue, but it ignores entirely evidence from the independent social worker who says this might be a mother who's very relieved about a placement for adoption and is likely to engage well with adopters, and might be somebody who adopters are more likely to be content to have open contact with. So that's the failure to engage with the detail and the specifics of the case. And in my submission, the manifest deficiencies are plain, and I don't want to detain the court longer. But those points, I think, ground and respond to the suggestion that there is any even limited engagement with the reality of the case. What is lacking is a balanced analysis of any sort. I'm not sure I can. I should, as a final point, say that in light of the circumstances and delay, we, and I'm sure I speak for all those across the bench, were exceptionally grateful at the Court of Appeal expediting the hearing of this matter in the way that it did during the vacation period. And I know that Mr. Hall returned early from a period of holiday in order to give consistency of representation to the mother, and I think again that is something that is recognition of a commitment to both this court and those at the bar to making sure that the appeal was properly heard swiftly, because plainly, given the age of this child and the need for urgent decisions, that is an absolute priority. And I think it's right to recognise that commitment on the part of Mr. Hall.
Well, it's very right of you to draw it to our attention, so thank you very much. Thank you, Mr. Hall.
My lady, modesty forbade him, but I know that Mr. Barnes is in the same position, that he'll also interrupt us. So.
Well, it's going to be a mutual appreciation society, I'm sure. Would you just remain? We'll see where we are and what's going to happen next.
Court rise, if able.
Can I just go outside and
Oh
check?
yes, yes. With first of all is can you go outside
Is it, are the cameras on?
the lash is yeah. So sorry. The case. Court rise if able.
Mr. Barnes, you're still on your feet. We are going to announce the decision today because obviously things need to get moving.
Thank you.
And the reasons will follow in a reserved judgment, which we'll get to you as soon as we might.
Thank you.
But in the meantime, we allow the appeal. We are going to remit this case for rehearing. We are not going to limit it, as you suggest, Mr. Barnes. The court below must have a clear notebook, as it were, to proceed upon. But it is very important, obviously, that we get this matter back before the court as soon as possible. Now, we intend to direct that the family presiding judge for the relevant part of the South Eastern Circuit, whom everyone thinks is Mr. Justice Williams,
Yes.
shall give directions as to the judge who shall determine the case. It's obviously got to be somebody other than Honourable Judge Scarratt. And I intend to send a message to the President's office today to ask that his vacation be interrupted in order to at least make that nomination.
Yes, I think Mr. Justice Williams, just from communications on other cases, isn't sitting at the moment. I think Mrs. Justice Tice may be due to sit next week.
Right.
So it may be that if we make investigations, there's an alternate judge who may be able to assist.
Yes.
But I don't think she's the presider for the area, but she may be
Yes.
available to make the decision if there's
Is
a
Mrs.
difficult...
Justice Tice returned as a presiding judge to the area?
No, it's only that she, I know, is sitting in this vacation period.
Oh, I see.
What I will seek to do is communicate with Mr. Justice Williams' clerk to ascertain whether he's in a position to make the decision, or in the alternative, try and identify where that inquiry might go following court's
All right.
decision, if that assists.
So we'll want counsel to put together an agreed order for our approval,
Cool.
given our decision. There's going to have to be case management.
Yes.
We don't know when counsel involved in the case so far are going to be returning to their normal duties.
Well, I know that Milena Friends were appeared at the trial, but I imagine that we would be able to manage matters subject to the court being able to list over the summer.
Yes. Yes, absolutely. Yes. My Lord makes the suggestion, which I think everyone will approve of, that if you give your availability in terms of not being on holiday, that would assist for listing purposes, wouldn't it?
Yes, I'll collate and ensure that that's before the court. Given that I didn't appear below, I don't know what the position will be in terms of those who instruct me. So I suspect the priority is Mr. Hall and Ms. Thompson over myself.
Yes, of course.
But
Well, the priority, of course, is the child, as you know, but we
no,
will
I just meant in
obviously
terms of
see-
continuity of representation as opposed to myself.
Yes, we see her welfare as being advanced by continuity.
Thank you.
Thank you all very much indeed. If you can get a draft of that order through, you have my clerk's.
I do.
Email address
If my lady had the email in the
Yes.
course of the hearing, then that is the line of communication that is
Yes.
easily operational.
Yes, yes. Thank you all very much. Thank you, Mr. Barnes. Thank you, Mr. Hall, for returning from holiday to deal with the case. Thank you, Ms. Thompson, for appearing. Thank you for those who sit behind you. But most particularly, thank you to the mother, because it can't have been easy for you to come today. I'm sorry that you've got to have the hearing all over again, but we hope in the meantime that things go well for you. And thank you also to the social worker who sat behind you, Miss Bond, as well throughout.
Court rise if able.